All right, hello. Looks like people are starting to join, so I will get started here in a second. We got a couple more minutes till actual start time, but just I'll let you know I'm here. Actually, look, Jenny, I guess I can see the participants. It looks like it's just you and me. So we're good for now. A couple more people joining. Give it a couple more minutes here. All right. We just hit noon and we have some intro items to start with, so we'll probably go ahead and get started. Thanks for everyone who's attended, who's joined so far. I'm sure we'll have a couple more join here soon. I have a presentation here on safe financing, so we're going to go over that. And initially, though, I wanted to give you a little background on me, just so you know where I'm coming from. So my name's Trevor Crow, and I'm an attorney and co-founder of Doida Crow Legal. And I graduated law school in 2009 and received an LLM in taxation also in 2010 from the Denver University Law School. And the Doida Crow Legal is a firm we're focused on representing entrepreneurs. And so this typically comes in the form of representing startup companies, preparing entity documents, doing securities work for those companies that are raising money, and then ultimately representing buyers and sellers in the business purchase and sale transactions. And our goal is to become the go-to business transactional firm in the Rocky Mountain region. We're here located in Denver, and most of our clients are along the Front Range. But for those of you joining, I know this was blasted out on the internet and social media. So those of you joining from anywhere, all the stuff we talk about today are not state law specific. Most of this is governed by contract law and federal law, and that's going to be the contract law piece is state law, but it's going to not vary much between the states. And then the securities laws are federal and state, but we're going to mainly be focusing on the federal aspects of that. So that's me. There's the bio. All right, so let's go ahead and talk about the agenda today. So first, we're going to talk, what is a safe initially, and just kind of get into what that is and what it means when you're offering a safe. We are going to touch on the securities laws that apply to when you're issuing safes, and then we're going to talk about the different terms of a safe, and then the documents, pre-closing, post-closing items that you need to handle. And so that's going to be our agenda for the day. you can, just another housekeeping item here. If you want to ask a question, because I think there's a setup in webinar mode, you have to hit the chat button or maybe the Q&A. Either way, I should get notified when you have if you have a question. So feel free to hit the chat or put a question in the chat or the Q&A box, and I should be able to see that pop up and try to answer the question. So no need to wait until the end. We will have a Q&A session at the end just to see if anybody else has any questions, but otherwise, you can just put them in the chat as we go. So, initially I would say when you're thinking about financing, discussing what the options are important to talk about in the very beginning. And so we always like it when our clients call us early in the process and say, hey, we're thinking about raising money. Let's talk about options. And the reason for that is because when you're going out to form a company, especially at the initial stage, you've probably been thinking about it for a while, and you're thinking about what the company's going to be, what the business plan is, things like that, and you're talking to people about it. And so you're going out and you're talking to people, asking them what, telling them about the idea, getting feedback, that sort of thing, and maybe even talking to friends and family about potential investments. And when you're doing that, you want to set the appropriate expectations from the beginning. So again, that's why one of the biggest things we ask clients to do is to contact us early so we can talk about these, so they don't go out and talk about offering common stock if we're really going to be doing a safe offering, or offering preferred stock or convertible notes, anything like that. It's nice to have those options known in the beginning. That way, when you're going out and talking to people, that the founders know, or the founders are setting appropriate expectations with potential investors in the future. So that, just wanted to mention that at the outset. Let's see, next. All right, so let's get into it. Let's get into what is a safe. And by the way, we plan to go probably 45 minutes here and then open up for Q&A. And, depending on whether there's questions along the way, that may be longer or shorter, but, we'll get through the material here. So SAFE is really just an acronym, and it means Simple Agreement for Future Equity. And it's, used in the early stage startup companies that are raising capital. And usually they're raising capital from angel investors, friends and family. And it's used prior to getting institutional or venture capital financing. So this is not something that VCs typically, an instrument that VCs typically invest in. This is kind of early stage, just getting that seed capital. Usually those investors are friends and family type people. And this is often, the most vital round of financing for a company. They need to get some money in the door to either buy equipment, keep their lifestyles, or allow the founders to be able to pay their mortgages while they're running the company, or potentially to hire employees as well. And this is an exciting time for the company at the startup stage and for investors to come in. And so this is kind of the earliest, and are used in the earliest stage, and really the riskiest stage of a startup. And so these are just really common. Safes are common for the first seed financing for startups. And this seminar is going to kind of outline the process and key considerations for those startup companies when they're issuing safes to raise capital. And so a couple assumptions that I'm going to have here. I'm going to assume that the company is raising capital as a startup and it's organized as a C corporation, most likely a Delaware C corporation, but it could be a corporation in any other jurisdiction. But just know, because I do get this question often, that all the concepts that we talk about here with safes can be adapted for use in an LLC as well. So LLCs, that we've had plenty of clients that are LLCs that issue safes as well. So we just, the terms change, but just for purposes of talking about, stock versus membership interests and things like that, I'm just going to assume that this is a C Corp, and so all the terms are kind of be related to a C Corp. But again, this could definitely be used for an LLC as well. All right, so let's see here next. Okay, so safe. What are the key terms of a safe? The key terms really come down to the amount to be that's going to be raised, and that's going to be reflected in the safe itself. So when somebody invests in a safe, they're going to invest a certain amount of money, and that amount is obviously going to be represented in the safe itself, the safe document, which we'll talk about more later. But there may also be a presentation or a term sheet that is put out there in the beginning of a safe offering to investors, and there may be a maximum raise that's put out there. Now, maximum raise is really, my recommendation to our founder clients is that they put a substantial cushion in the amount that could be raised there. That way, if they're getting more investment or more activity, more engagement from investors, they can actually raise that money. Oftentimes, things take longer and are more expensive than people think. And so having that cushion is nice. Whereas if you say you're only going to raise this amount and you have more interest and you try to raise that more money, then other investors may come back and say, hey, I thought, I didn't plan to invest in the round that was this size. I was planning to invest in a smaller round, that sort of thing. So you want to make sure you have, if you do set a maximum amount, that has some cushion in it. Another key term is the valuation cap. And we're going to get into that more here later, but the valuation cap basically says that this is the max amount of company valuation that this safe will convert into equity. Because that's one of the, as you can see in the slide, the key characteristics of a safe is that it converts to equity upon certain triggering events. And so that's really the idea behind a safe. And the valuation cap is there as a protection really to the investors who are investing at this earliest, most riskiest stage of the investment from a really high valuation that comes later in a Series A. So, if I'm a safe investor and I put in money from the beginning, I'm investing at that riskiest time. And if that money that from me and all the other safe investors goes to help build this company into something really big quickly, and then they have this really large Series A valuation, I'm going to get converted at a very low or low percentage of the company at that point. So my investment which was the key to getting this company to the next stage, is really going to convert into a very small amount. And so, we have a valuation cap is really an investor protection that might be in a safe to say, we're not going to convert to equity at any price lower than or above this amount. So it's a cap on that valuation. The next term is a discount rate. So oftentimes there's a discount rate. Again, this recognizes the fact that a investor in a safe is investing at a riskier time than somebody who comes in at a priced round. So the discount rate basically says, hey, if that next equity financing, which is the triggering event for when that safe converts to equity, is at a $2 million valuation, let's just say, well, I'm going to get a discount on that. So the price per share of these investors coming in at this price round is a price per share that's calculated based on a 2 million valuation. Well, I'm going to get my price per share is going to be that 2 million times the discount rate. So it may be a 20% discount rate or something like that. So I get a 20% discount on that 2 million valuation when my safe converts into equity. So that's another key term to have. And then the other thing is a corporate transaction multiple. So that's the other typical conversion event that's built into a safe is a corporate transaction multiple. So it says, hey, if you don't raise, let's say the company goes along and instead of raising that next round of equity, it sells the company. You took the money in on the safe and invests, uses that money and builds a company. And now instead of taking on the next round, it sells to a strategic buyer, for example. And in that would be a corporate transaction. And so your safe would convert at that corporate transaction upon the occurrence of that corporate transaction. Oftentimes the safe investors want some sort of multiple on that. So if I've invested $100,000, then maybe I get 2 times that at a corporate transaction conversion. That's highly negotiable provision. Sometimes these safes will have a corporate transaction multiple. Sometimes they won't. All right. So what else here? The key characteristics, I kind of talked about that already. That's going to be that this is it's currently just money that goes into the company under this safe, and it has no equity piece to it initially. But at one of these conversion events, which is, like I said, either the next equity financing or the corporate transaction, it does convert into equity. And so, priority and security of this investment is they're unsecured obligations of the company. So safes are almost always unsecured obligations. So there's no security interest that helps protect that investment. It, if the company goes under, there's no liquidation preference or anything like that. It's really just treated as an unsecured obligation. Usually it's paid, the way it's treated is as kind of like preferred stock, for example. So it's below all other creditors. All other creditors get paid first that have debt to the company. So in a liquidation event, if the company doesn't make it, the creditors get paid first, then the safe holders, and then if there's any remaining at the end of the day, that would go to the equity holders. So it's kind of that in-between stage is where the priority of a safe on a downside event. All right, let's see here. Next slide, let's talk about the advantages of a safe. So the advantages of a safe are, first one is that it's very beneficial, in my opinion, to the founders, so to the company itself. And the reason for that is because the safe is not, as opposed to preferred stock, which has a liquidation preference, or convertible notes or straight debt, it doesn't have a maturity date, and it doesn't have a interest rate associated with it. So convertible note will typically have a maturity date and an interest rate. Safes do not. They don't have a maturity date, and they don't have or typically, safes can be modified or whatever, and so you may see something called a safe and then have different provisions in it. But for the most part, a typical safe is not going to have a maturity date or an interest rate, and so that's why that gives the founder some peace of mind, honestly, that there's no maturity date, so they're not against the clock like on a convertible note where they have to have that next equity financing or that corporate transaction within a certain period of time to ensure that they don't have to pay back that note. On a convertible note, they'll have that amount becomes due at some point. The safes don't mature, so it gives the founders a little bit more peace of mind there. But it's also not as good for the investors in that standpoint. There's like I said, it's beneficial to the founders, it's beneficial to the company. The next advantage is that it's just simple. It's right in the name there. Simple agreement for future equity, and it's usually it's a short document. There's fewer negotiated terms, really only the discount rate and the valuation cap or what get negotiated in there. And it's pretty simple to put together. So that's going to also lead to that third advantage, which is lower attorney's fees. The cost of putting together and documenting a safe round is generally a lot less when you compare that to a convertible note financing, although convertible notes aren't too difficult either. And it's certainly a lot less than doing a priced round, a preferred equity round. One of the other advantages, which isn't on the slide though, is the equity incentives. So similar to convertible notes, the equity incentives that you can provide as a company, if you want to go out, if the company also wants to bring on talent, wants to issue options or restricted stock, it doesn't provide a valuation. There's no valuation at the time of issuing a safe. So you're kind of kicking the can down the road on valuing the company, which makes sense at the early stage. You just have an idea, you have a group of founders, and they have a business plan. And so the value of the company is based on, the idea itself and what the potential market is for that idea, and then the investor's confidence that the team, the founders, are going to be able to execute on that plan. And so it's really hard to pull a valuation, right? It's kind of pulling numbers from the air because there's no, you can't do a discount cash flow model. You can't do any of these things that valuation experts go out and do for operating companies that have revenue and things like that. So, and how that plays into equity incentives is once you have a priced round and you have a valuation of the company, when you're issuing options to or restricted stock to employees, you can't really go below that valuation because you already have this. And you want to issue these shares to employees at the lowest rate possible, initially at least. And once you have that price round, you can't do that. You have to stick with what you have out there or what's been the value of the company. And so it really doesn't affect your ability to issue shares of restricted stock at a very low rate. So that's one of the benefits I see of both safes and convertible notes. All right. What about disadvantages? So the disadvantages that I see with a safe is that, one, they can be hard to sell, and they're hard to sell to friends and family sometimes, because if they're used to startup investing, they may be fine with it. But if they're not, they're going to look at this and say, hey, there's no maturity date, there's no interest rate. I'm just giving this money to the company at this point in hopes of a later conversion. And there's not really anything that forces the company to pay me back my money, right? And so that sometimes makes it a hard sell. The other thing is uncertainty. So uncertainty on what that conversion is going to be and what the cap table is going to look like. From a founder's perspective and from an investor's perspective, this uncertainty, I think, is a disadvantage. If that company has to go raise money at a very low valuation, these safes could convert into a good percentage of the company. And so there's just uncertainty in what the cap table looks like at that later round. And so that uncertainty can kind of cause some concerns on both sides. The no maturity and no interest, that's I mentioned, and that's kind of goes into the hard sell piece. And I think that makes it tough for people to invest. The other thing is kind of the tax treatment. So there's a little bit of tax professionals are still really trying to figure out what the proper tax treatment for safes are. And so there are some drawbacks to that. I'm not going to get into all the details of that, but there are some issues, because it's kind of that in between. It's not debt, it's not equity. So what is it? And so there is some issues there with the tax treatment. And so something to think about there. Let me see here. All right, so I have some notes here on similarities between safes and convertible notes, which are probably interesting to point out. So safes have been around for a little while now. So you've probably heard about safes if you're on this webinar. It's not a new term to you, most likely. But they are still relatively new compared to things like convertible notes. It wasn't that long ago that the first safe kind of came out, and it was popularized by Y Combinator, and they kind of put out this document as a way for their companies in Y Combinator to raise equity, or I'm sorry, raise money, not through equity, but through the safe in a quick fashion. And I think safes are really easy to use for those type companies. If you're in a Y Combinator or in one of these well-known accelerators, there's a group of investors who all are lining up to invest in your company, hoping to be the next Airbnb or Uber or something like that. So everybody wants to invest, and so it's easier to sell it to those investors who are interested in it. Because these are the founders who've kind of been through a vetting process to make it into that accelerator. And so I think that, but that outside of that accelerator situation, there is some unfamiliarity. Sorry, pronunciation stuff today. Some people are unfamiliar with the safe, and investors may have a hard time kind of getting over that. But there are a lot of important features that are similar to convertible notes. For one, the conversion events. So the fact that it converts to equity at a later time, that's very similar. Conversion prices. Usually in a convertible note, you also have a valuation cap, and you have a discount. And priority on liquidation is pretty similar as well, in that they're kind of treated in between the debt and equity holders on who gets money first on a liquidation event. And so typically for a convertible note, there is a maturity date and interest rate. So there is a point where that note becomes due. So it could just be that the company owes the money as debt at some point at that maturity date, if one of the triggering events hasn't occurred. Whereas the difference with the safe is there is no maturity date. So you're really just waiting for that next equity financing or the corporate transaction to convert. So yeah, I think that's an interesting thing to put out there, just so you know, they are fairly similar to what a note would be, absent the maturity date and the interest rate that's associated with the note. All right, let's see next. All right, and so I also included in this slide, just because I think it's important to also have a little bit of a background on, when you say what are the advantages and disadvantages of something, you kind of have to compare that to something. And I think the advantages and disadvantages that I mentioned kind of apply to how they're advantageous or disadvantageous compared to both convertible notes and to price rounds. But let's just talk about a price round for a second here. A price round is typically done in a corporation with the issuance of preferred stock. It could be a Series A, it could even be a Series C. People have different terms for what they're calling them these days, depending on the stage of the company. But it could be one of those. And the price round says, hey, here's the valuation of the company. Here's the pre-money valuation. Here's the post-money valuation. So if we have a pre-money valuation of $4 million and we're raising $1 million, and so the post-money is going to be just that pre-money plus the money that they're raising. So that's 4 million plus the million equals 5 million. Then those new investors would get 20% of the company, right? Because they've invested $1 million out of a $5 million company. And so they would get 20% of the company. And so, and that's how it would work in a priced round. And so you would issue the preferred stock. Some of the advantages of the price round are, the certainty for investors and founders. What the cap table is going to look like. You have, it's all spelled out. It says, hey, here's the value pre and post money. Here's the amount of shares we have to issue for those new investors to have 20% of the company at the end of the day. It also gives you a little bit more of a roadmap for future financing. So you know what your valuation was. You have everything put into your articles of incorporation or your certificate of incorporation, depending on where you filed. If it's in Delaware, it's called a certificate of incorporation. And it has a roadmap of, here's what we have, how many authorized for common, here's how many shares we have authorized for preferred. And then you have your, stock ledger that shows this is how many is outstanding at the time. Price rounds are also familiar. People are used to it. They say, all right, now I know I own this many shares of preferred stock. So I own, 1,000 shares of Series A preferred stock. And I know what I'm getting. And it's familiar because most people, the issuance of stock, the raising money by issuing stock has been going on forever, for a long time here. So that's very familiar. Disadvantages of a price round is the complex documentation. So, you're going to have a lot more agreements that are involved in a price round. There's going to be usually the company's at a later stage as well. So, it's been operating for a while, but you're going to have usually a Series C or Series A preferred stock purchase agreement. You're going to have to amended and restated articles of incorporation. There could be other things like indemnification agreements, could be voting agreements, could be, other agreements that the key holders are bound to on right of first refusal and things like that. And so there's just a lot more documentation involved. It may also have that stock purchase agreement for the Series C or Series A preferred may also have, disclosure schedules, reps and warranties, things like that the company needs to provide. And so it just makes the whole documentation of the process a lot more complex. All right, sorry, I was checking to make sure I didn't have any questions sitting out there. And another, that complexity just leads to more expensive, right? So there's more attorney's fees that are involved in putting together a price round, and so that's also a disadvantage. The third one here is the equity incentives, and that's something I've mentioned a couple times here. The equity incentives, now that we have a price round, let's just say, go back to that example of a 4 million pre-money and a 5 million post-money valuation. Now we have a value for the company. And so if I want to issue shares as either restricted stock or options to employees, there's a price that we know that we have to put on that. We can't just issue restricted stock at a 0.001 cent per share or something like that, likely we issued those preferred shares at a higher valuation, and so now we can only issue those shares to employees at that same valuation. And so that kind of what it can do is limit what you can do from equity incentive plan perspective. Once these companies, a lot of the companies, Airbnb and Uber, they were private for a long time. Now they're public companies, and so you can buy and sell stock on the exchanges, and the price. There's a public market for it. But before that, they still had high valuations. Before Uber went public, it had a very high valuation, still raising money at a very high valuation, and so they couldn't really issue restricted stock to employees anymore at that point. I imagine, obviously we didn't represent them in any of these transactions, so I don't know for sure, but I assume that they stopped issuing at some point. The valuation got high enough that they didn't issue restricted stock anymore. And the reason for that is restricted stock, when it's issued to employees, is compensation to them. And so it's easy to issue the compensation to them when there's really no value to it. When there's no value to the shares, you can say, hey, we're going to issue you 1,000 shares of restricted stock. It's got a 0.001 value per share. So very, very small amount. You file an 83B election, you pay tax on that very, very small amount right now. And then in the future, when it vests, you can you get that tax free. It vests and you own those shares and it's tax free at that point. You obviously get taxed when you sell it, but you get taxed at the capital gain rates. And so that's a very useful tool for startups to use to attract employees in the beginning, is restricted stock. But those same 1,000 shares, 4 years into Uber's operations, are now worth $100,000, let's say. And so if I issue that restricted stock at $100,000 to that employee, they don't want to file an 83B election because now they have $100,000 worth of income that they have to put on they have to pay tax on as ordinary income, and they have no cash for it. All they have is this illiquid stock, because at the time it wasn't public, right? And so that becomes a problem. So that's why that's the crux of the issue with equity incentives, and why when you have a price round and that price round gets high enough, it kind of takes away the ability to issue restricted stock. You can still issue options. My thought is that what happened at that point in Uber's life cycle is that they just issued options. And so they said, hey, we've just raised money at this, at $1 billion valuation. We're going to issue these shares, and it's going to be at a strike price of whatever those shares are worth at our $1 billion valuation. And so now those employees have those options, but they're subject to vesting. So they're subject to vesting and they're subject to exercise. So really those employees only exercise those options if the price increases. So if my strike price is at $1 billion valuation, then I'm only going to exercise that option if at the time of exercise there's a $2 billion valuation at that time. Some increase over the $1 billion over the prior valuation when they were issued to make it worthwhile for me to do that. So that's kind of the issue there. And here, let me see. Looks like I got a question. Building a corp transaction multiple, is it acceptable to build the multiple off of a scaled EBITDA? For instance, if your business gets purchased for 10 times EBITDA, then the transaction multiple back to the investors 2 times investment, and if purchased at 15 times EBITDA, then 3 times investment. Why would you not want to do this? Okay, so yeah, I can answer this. I'll just answer this live instead of typing it up. But you can do that. I mean, these are contracts, so really there's no nothing that stops you from putting anything in the contract, or very, very few things that stop you from putting in the contract that's not going to be okay, as long as everybody agrees to it. So certainly you could put in a multiple that's scaled depending on some multiple on whether the corporate transaction is based on a certain multiple of EBITDA. And so why would you want to or not want to do this? My thought is the only thing I would say on that is the devil's in the details on how you word that. So, maybe it would be based on just because you don't know what there's going to be potential add backs to EBITDA and things like that at the sale, at the time of sale. And so you want to just make sure that you have you clearly define what is EBITDA that we're talking about and what is the multiple. It's got to be determinable. And so maybe in that, if I don't think I've ever drafted one like that, but if I were to draft something like that, I would probably make that EBITDA determined in the reasonable discretion of the board, so that the board has a fiduciary duty to its shareholders. So, but to make that determination of what the multiple ultimately is final and not something that can be contested unless it's totally unreasonable, right? So that the board has in good faith is going to put together what that EBITDA number is in determining what the sale multiple is, because again, that what is EBITDA may depend on how you look at the financials there and what sort of add backs are put in or not from the buyer and seller standpoint. So, but certainly you can put that in. And in fact, there is similar to that, and I think we'll get into it later, is this the discount. Sometimes the way we structure the discount is a sliding scale. So it's not just, hey, you get a 20% discount. It may be something different than that. It may be, hey, you get a 10% discount if the next equity financing happens in the next 6 months. Because then, are they really taking a huge risk on that 6 months, on just that 6 months period? Maybe not. So maybe that discount rate should be lower. And then if the next equity financing happens or the corporate transaction happens in 6 months to 18 months, then it's 15%. And then anything after that is 20% discount, something like that. And we've done that often on convertible notes and safes. Well, actually, probably, I don't know if I technically have ever done that on a safe, but I've certainly done that on convertible notes before. But there's nothing that would stop you from doing that on a safe. So hopefully that answers your question. If you have follow-ups there. Oh, that's Aaron. Aaron, thanks for the question. All right, next. So securities laws. Let's talk about those quickly here. So securities laws. Here's your options. You're either registered. When you're issuing securities, they're either registered, exempt, or legal. And as you probably guessed, you don't want to be illegal. And the registered piece, you don't want to be either, especially in a safe offering, because a safe offering is typically for a lower threshold of money. It's at a startup stage where a company doesn't want to be public. A registered offering is like an IPO. That's where you file a registration statement with the SEC. And it's a very complex and expensive process to do, and it takes a long time. So you're not gonna have a registered offering here. So that leaves us one option that we need to focus on, and that's an exemption. And so we need to find an exemption from registration for the sale of these securities, both at the state and federal level. And so most often times these are used. You may have heard the term Reg D. Regulation D is rules that are promulgated by the SEC. And it basically rules that say, they're safe harbor rules that say, if you comply with these rules, then you are not making a public offering, and so you're going to be exempt from registration. And 506B is one of the most often used for sales of securities under Reg D. So 506B says you can raise as much money as you want, and you can raise it from as many accredited investors as you want. You can raise it from up to 35 non-accredited investors. But the problem with that is that there's usually some disclosure requirements that come with selling to non-accredited investors. So most oftentimes we're going to say sell only to accredited investors to avoid the disclosure requirements, because you're not going to want to have those disclosure requirements for a startup company. And so if you're selling to friends and family, you're really just looking for those friends and family that are accredited investors. And then there's no mandatory disclosure requirements. It preempts state law under 506B, and so that you don't have any state law filing requirements other than the states may require you to file a Form D in the specific states where you're raising money. And at the federal level, you would file what's called a Form D as well, which is really a short disclosure document that says, hey, we're out there raising money. We're raising up to this amount, and we're relying on this exemption. And that's free to file with the SEC through the EDGAR system, although the states usually charge a fee for you to file that if they require it. The other potential exemption that people use is Rule 504. Again, it's under Reg D. The only difference with that is it does not preempt state law, so you have to find state law exemptions as well. And so the benefit of 504 is that you can sell to non-accredited investors without having disclosure requirements, but you do have to comply with the state law. So usually a 504 offering works if you're raising money through safes and just maybe you have very few investors in very few states. So if you have, 5 investors that are going to invest in this safe, and you have, 4 of them in Colorado or say 3 of them in Colorado and 2 of them in another state that also has an exemption, most likely you're going to find a self-executing exemption that works in those states. And so 504 will work at the federal level, and then you'll have whatever the self-executing exemption is at the state level in those 2 states. So that's also a securities exemption that's often used. All right, let's see here. Let's talk about, all right, so reps and warranties, typically those, you don't find those in safes. So as opposed to a priced round where you're offering preferred stock, you're typically going to have that stock purchase agreement. It's going to have reps and warranties from the company, and it's going to have disclosure schedules that go along with that. One of those reps and warranties may be, we don't have any litigation. The financial statements that we presented accurately represent what the financials of the company are, things like that. Typically with a safe, you're doing it at such an early stage in the startup that there is no reps and warranties. So that's nice from the company side. From the investor side, you typically have reps and warranties from the investors saying that they're accredited investors. And these are really just securities law compliance reps and warranties, that 1, they're accredited investor, 2, that they've had the opportunity to ask questions, and they're sophisticated in investing in these type companies. And so those are some of the reps and warranties you may have from an investor here. But for the most part, for safe financing, you're not going to have a lot of reps and warranties that you have to deal with like you would with a priced round. Okay. Now, and I say that with a caveat because this is all negotiable, right? You may have an investor that comes in and says, hey, I'll invest in this safe, but I want you to provide some reps and warranties, or the company to provide some reps and warranties about the company. One of those may be that all the intellectual property is owned by the company. So there's, been assignments from the founders of IP to the company, so that there's no issue later that any founder says, oh, actually I own that IP, not the company, and because that really is what goes to the worth and value of the company. And so that might be important for investors to know. They may also want to know, that there's no litigation. Again, typically for a new startup, you're pretty certain there is no litigation, but the other one may be that the company's duly authorized to actually issue the safes. So those are pretty simple reps that an investor may ask for. But again, oftentimes they're just friends and family who are willing to put up money, and at its stage of the company that's very early and before there's any valuation that's put out there on the company. So that also makes it quicker to get the money in the door from a founder's perspective. All right. Other terms, discount rate. We kind of talked about this already, and this is where you can see on this slide here, I have the sliding scale rates. That's the typical range that we see for safes and convertible notes is going to be between 10 and 30%. The higher the discount rate, the better it is for the investor. The higher that percentage is, and the lower it is, the better it is for the company, right? Because it's going to lead to less dilution of the company at a lower discount rate. And so typically, like I said, we see between 10 and 30. I would say 20% is most common. And then we also have the sliding scale rate, and this might be, like I said, a 10% discount if that next equity financing occurs in 6 months. After that 6 months, it's going to be 20% up to, a year and a half. And then after that, maybe it's 30%. That could be a way of structuring it. And especially if you're kind of having this negotiation with investors, if you're a company founder and you're having these negotiations with investors on what that rate should be, and they're saying, no, it should be 25%. You're saying, no, I think 20 is pretty typical. Maybe you put in a sliding scale in there, and it kind of makes both parties happy on what it is. Because again, if that conversion event happens 6 months down the road, they didn't really take, that first investor didn't take as much of a risk as maybe anticipated in the beginning. So a couple ways to deal with discount rate. Valuation caps. That's the next one. So, who benefits from a valuation cap? And the answer to that is that it's the investors. Investors, what they're worried about, again, and I kind of mentioned this in the beginning, is that there's going to be some crazy Series A valuation down the road that now they get converted to a 0.001% of the company, even though they put in the startup capital for this company. And so they want to make sure that when they convert, that at the maximum, they're converting at this valuation, right? And I think that makes sense in safes more than anything, because you're not getting an interest rate. In a convertible note, the principal you put in and the interest that's accrued is what converts into equity. Here, there's no interest rate, so your money just went in, and it didn't increase in value over time. So there was no time value of money increase, and so I think that the valuation cap and the discount rate, is easier for an investor to say, hey, we should have this, or we can negotiate for that. But really, again, the valuation cap is just a ceiling on the amount of the amount that money that they've invested in the safe will convert to equity. You want to be clear in that whether it's a pre-money or post-money, right? And so the pre-money or post-money is going to say, is this cap based on the valuation pre-money or post-money? So again, in my $4 million valuation pre-money, $5 million post-money, that could be the next equity financing, right? If that company had issued safes before, and now they're doing a preferred stock round, and they have that $4 million pre-money valuation, $5 million post-money, then that's the point where they would say, which one of those counts as the valuation cap. If I have you just want to make clear what that is, so that, if that valuation cap is 4 million, then does that mean pre or post money? And if that valuation cap is 5 million, is that pre or post money? Because that could cause an issue in that hypothetical, right? So something to consider there. Let's keep going. We're taking longer than expected here, but hopefully this is helpful. Term sheets. So, oftentimes conversations between startup founders and prospective investors are going to be talking about the business concept and the market opportunity. And a lot of times there's no lead investor who's putting out terms or asking about terms. And so you may not know who wants to invest. If you have that conversation with friends and family, and they say, oh yeah, I'd be interested in investing. That's a lot different than actually putting together a term sheet and having somebody sign it and say, yes, I'm interested in investing on these terms, right? So oftentimes what we do is we put together a term sheet that founders can circulate. So they go out and they circulate this term sheet. It says, hey, here's the major terms we're looking to raise money out on, and try to gauge interest. There may be some negotiation at that point, especially from lead investors that say, hey, I wanted a higher discount rate, or I think the valuation cap should be different, something like that. And so there may be some negotiation, but generally you want to kind of get enough investors soft circled on a specific term sheet, and then you go out and raise money on that term sheet with everybody, right? Or on those terms with everybody. So once you have a few investors on the hook and they want to invest on those terms, then it becomes a take it or leave it situation for other investors, right? So if you have your main couple investors in the door and you say, all right, here's the terms that we're raising money on, these people have accepted it, let's move forward and get raise money on these terms. So a term sheet is very helpful for those situations. One thing I also have a note here is startup companies is if you're doing this at the very startup stage, right at formation, you want to make sure that you have, we had a company that we kind of worked with and we realized that they hadn't even set up a bank account yet. So, and we had the company had been formed and there was safe documents gone out, but they didn't have a way to accept the money. So I don't think most people that would happen to most people, but that's how early stage these things can happen. So you want to make sure that you have a bank account. So now that's on my checklist to say, hey, you guys have a bank account, right? To make sure you can take this money. All right, ancillary documents. So other documents you may need, you're going to need the resolutions to approve the safe offer. So you're going to need a board consent that's saying, hey, the company's authorized to issue these safes. You may have side letters. This would be a situation where you have one maybe major investor who wants some additional terms. And so you just enter into a side letter with that one investor as opposed to all the investors. And then due diligence and disclosure documents. Again, I don't see it often happen with safe offerings, just because it's usually so early stage. There isn't much due diligence and there's not much to disclose. So there's not usually much of that, but it could be something that somebody asked for. All right, closing and post-closing items. So, we have securities laws compliance. Again, depends on the offering, but if it's 506B, you have to file what's called a Form D with the SEC within 15 days of taking your first investment. And so that's something to be aware of. You also have potential blue sky filings, which is going to be the state law Form D filing. So, if all your investors are in a certain state, you'd want to check those or have your counsel check those blue sky laws to make sure that there's no filing requirements, or if there are, what they are, so those can be handled. And then, post-closing, it's just putting together, making sure everything gets signed, right? So you have the notes signed by the company. Some investors are going to want the original safe signed by the company and sent to them. And so you might have to do that. And you may have to, if you end up raising more money than anticipated, and so the Form D was filed with a certain threshold amount of investment, and you go over that, then you have to file an amendment to the Form D. So there's a number of things that you might have to do post-closing, but really it's just making sure you get all the signatures on everything and updating the cap table to reflect that you have issued these safes, so that you have an accurate cap table of who owns any actual equity and who owns anything that could convert to equity. All right, let's see. And then lastly, choosing the right financing. I think we're coming to the end here, so I'm going to stop it and ask for questions, but these are kind of the options, right? That most C Corps that are startup companies that need to raise money are going to be looking at. Safes and this is kind of, except for I would switch preferred stock and common stock in this list. But otherwise, they're in order of complexity, right? So safes are going to be the easiest, convertible notes next, and common stock. If you're issuing common stock, it's easier than preferred stock just because they all have the same rights. There's no liquidation preference. There's nothing like that's associated with the common stock, and so the amendment to the articles and things like that becomes easier. And then preferred stock would be the most difficult. But there's others, there's people touting new things all the time. Recently we had a client who was asking about doing what he was calling a seal. And I made a note of that, and now I can't even remember what it stood for, but it was basically a royalty type financing where a percentage of the profits were made to the investors over a period of time, and then converted to equity. So, it was a different sort of instrument, but again, these are all governed by contract provisions, and so you got to comply with the securities laws, and then you have and then it's just contract law, right, that governs these, and so you can really kind of structure them however you want. All right, looks like we got another. Could someone use safes? Hey, David, could someone use safes to gather funds to do an acquisition and then use the acquisition as an event that triggers equity conversion? Sort of like a SPAC light. Yeah, certainly. I have not done that, but I think that's a very interesting question and an interesting way to go. Because I know David does a lot of M&A work, and that's for the search fund type M&A people out there who are looking to buy a company, buy an existing company, as opposed to a startup company just raising money, starting it from scratch, a lot of times those people looking to buy the business need to raise money to buy the business, right? So they may get a loan, but they also need some equity injection. And that equity injection can come from the sale of shares. It can come from the sale of, convertible notes. It could come from the sale of safes. And so, certainly you could have that safes as a way to gather funds to do acquisitions. Now, my worry is that safes, more than anything else, people who invest in safes have to feel comfortable that the company is actually going to have a conversion event, because there's no maturity date, there's no interest rate. And so, for a startup tech company that is either, it has kind of two options. It's either gonna grow, it's gonna either fold, or it's gonna grow and have to raise money, because they're just pumping all the money back into the company. They're not making distributions. And so you kind of feel more comfortable investing in a safe, because either you just lose your investment, which happens with startup companies a lot, and so you have to be comfortable with that, or it's going to grow and there's going to be a conversion event, because the only way they can grow is by raising money. With this situation, I would say, to buy an acquisition is what happens if that acquisition doesn't close. Maybe they're looking for the next acquisition and that sort of thing. But if I'm putting on my investor hat here, I might want some other conversion event or payback event. So maybe a convertible note would make more sense in that situation. Say, all right, I've loaned you money to do this acquisition. If that acquisition occurs, I convert to equity at this price. But if it doesn't convert to equity because the acquisition doesn't close, do I get my money back? So that it really depends what you can sell. So if that investor can sell, that company or that acquisition entrepreneur that's looking to acquire a business can sell a safe, that's great. But I just anticipate that there might be problems with that. But certainly you could do it. And again, you could do it with a convertible note as well. All right. Any other questions? I know we're coming close to the end here. 6 minutes left. Happy to answer any questions that anybody has. Let me see. I got another one here. Can you talk about the process? Oh yeah. So for us, if we do a lot of these transactions, safe transactions, or really any equity financing transactions, whether it's a convertible note, safes, preferred stock, that sort of thing. And so we're always looking for serious entrepreneurs who are interested in raising money. And so if that's you or somebody else please, we're happy to talk to them. We offer free consultations, so nothing out front, and only if they like what we're saying and they feel like they want to work with us, or if you want to work with us, then would we move to an engagement stage. And so oftentimes, especially with safe offerings, we come up with a fixed fee for it, so that the company and the founders know this is what it's going to cost. We put together a statement of work. We say, hey, this is what we're putting together for the transaction and what you're going to need. You're going to need your consents, you're going to need the safe document, and X, Y, and Z all the way down the road. Maybe going to need a term sheet, and we're going to put all that together, and here's the price, right? And so that way there's no gotchas, no surprises. And so that's certainly something we like to offer on these type of transactions. But anyway, if there is anybody who's interested either on this webinar or that please feel free to send them our way. I got put up my contact information right here. So send us an email, give us a call. Happy to talk. Let's see. I got another one here. Hold on. Oh yeah, we also put together a newsletter. Sorry, Jenny is reminding me here that we should promote our newsletter as well. So if you're interested in receiving, we put together a newsletter that has a lot of great tips and things like that on legal issues for founders and M&A professionals. We have if you email info@doidacrow.com, so just info@doidacrow.com, DOIDA crow.com. We can get you put on our newsletter list and get you signed up. So, all right, I think that might be it. All I see here, and now we're coming close to time, so we'll go ahead and wrap it up. Again, feel free if you have any other follow-up questions to send me an email. Happy to talk about this anytime. Thanks so much for everybody for joining.